Okay, I'll try to do better this time. I'm sitting down, I've taken pills. We'll see, and luckily I don't have to say much. But I have the pleasure of introducing the panel. I've been involved in human rights advocacy for over 15 years now, and we have certainly made some progress. But it does seem that as soon as there is discernible progress, a human rights backlash gets underway. And I think it's important to remember we're in the midst of one now. That backlash began to manifest itself in the media in vitriolic comments about political correctness, accompanied by statements implying that those vicious minorities now have all the money and all the power and are taking over. The persistence of aggression born of ignorance and fear was tellingly demonstrated in the media and in our legislature recently in the course of the defeat of Bill 167. That defeat was accompanied by a truly discouraging display of unashamed public bigotry by people who are not gay bashers. I'm privileged to be up here with people who are going to be involved in carrying on the pursuit of justice after Bill 167. I'm going to ask each of them to make brief comments, mainly on two topics. The first is, what are the important issues for the lesbian and gay community in real human terms? The second is, what remains to be done to address those issues? Litigation and law reform strategy issues, legal defense funds, class actions, interveners, and so on, all of those issues. I'm also going to ask them to do the impossible in that I'm asking them to maybe confine their remarks to approximately 5 minutes, whereupon we can throw the whole thing open to discussion, questions, comments, and so on. I should say right off the bat that the Reverend Mr. Brent Hawkes is not with us at this moment, but may breeze in late. The last we heard is that he was in, I think, a cabinet, either a Justice Committee session right now, trying to pick up some of the pieces after the nonsense that went on over Mr. Murphy's bill. And I guess if he comes in, I will sort of do his introduction then. Most of you, I imagine, know him. He's certainly prominent enough in the media. So I'll go on with the other speakers right now. On my immediate left is Karen Andrews, who is a longtime activist in the feminist, gay, and lesbian communities. She's just completed her articles at Cornish Advocates, and I know myself, she's very businesslike and to the point on her issues, and I think her remarks are going to be extremely enlightening. She's had also the double experience of being both on the lawyer end of things and on the litigant end of things, because of course she was the litigant against OHIP years ago. When was that, Karen?
Started in 85.
85, on same-sex benefits. Our next person on my next left is Mr. Tom Warner, who's a registrar of the Institute of Chartered Accountants of Ontario. He received his degree from the University of Toronto and holds, of course, professional designation, the ACIS, granted by the Institute of Chartered Secretaries and Administrators. He is a commissioner of the Ontario Human Rights Commission. I better listen up to his remarks, just to keep current. He's also a founding member of the Coalition for Lesbian and Gay Rights in Ontario and has been involved in many lesbian and gay rights organizations over 20 years. He was one of the leaders of the gay community's campaign to have sexual orientation added to the Ontario Human Rights Code. He's currently co-chair of the Campaign for Equal Families. To my farthest left is David Corbett, who's a litigation partner at Torrey de Laurier in Bennington and a partner in the International Partnership of Torrey Desjardins, Lawson and Lundell. He's also on the faculty at Osgoode Hall Law School and has taught and lectured in the areas of negotiation skills for lawyers, trial and appellate advocacy, and construction law. He's acted in equality rights litigation for various public advocacy groups, including the Canadian AIDS Society, the Canadian Mental Health Association, Metropolitan Toronto Community Church of Toronto, and the Coalition for Lesbian and Gay Rights in Ontario. And thank goodness that's all I have to say, so perhaps the speakers can take it away.
I'm not Andrew's Law Society, I'm not Andrew's Grandin Toy, I'm Andrew's Ministry of Health, and I come from a litigious family. I have been able to engage with law in a relatively unique way. I got my decision in 1988, and I decided that if you can't beat them, you might as well join them. So I went to Osgood and graduated last year. And law school has helped me understand better the problems and paradoxes of litigation. Now, my experience as a non-legal advocate was the most empowering and inspiring experience of my life, and my experience as a legal advocate was the most shattering. In arbitration, getting the decision, the entire issue of mootness. And those experiences have informed the way I have studied, and I hope they inform the way I practice. And it will come as no surprise to you that I think every doctor should be a patient and every lawyer should be a client. Now, things have changed profoundly since I began in 1985. The media coverage, I think, has been unprecedented. Our experiences are starting to become normalized. You know, we go to movies too, you know, like we walk our dogs, we are your neighbors. This kind of stuff was not seen before. We were criminals before. We were outsiders before. I'm a follower of Carol Smart. I think she writes very interesting things. She says whether we like it or not, when you go to court and you litigate, our claims become legitimate and accessible. And I think that this is what is happening. There is this percolating idea that we now belong to the fabric of society, that we pay taxes too, that we contribute to benefit plans. This is very positive. Employers have moved and pay these premiums, and unions are moving. I applaud the Law Society for this symposium. There are people who are here who would not have been here 10 years ago, and this event for me is about hope. Now, there are practitioners here, and I think what you have to understand, and what often you do not, is that when anybody, gay or lesbian, litigates an issue, and I think with the failure of 167, there will be more litigation because I think it has politicized lesbian and gay people, and there will be more of it. We're mad as hell, and we're not going to take it anymore. But when we come to you, we are risking our relationships. We are jeopardizing our family ties. We are risking our employment. We are risking our physical security. And often, it is the first time that we speak about our experience to an outsider. And it's a nerve-wracking experience. I mean, you can imagine a closeted woman lives in the burbs, you know, has custody problems with her husband, and she's got to go and talk to her lawyer about the circumstances of her life. And this is a very difficult thing for people to do. And I have the utmost affection and regard for the lawyers at Sachs Goldblatt, who were my lawyers. They treated me with respect. They were open to having Homo 101 explained to them. And what you have to understand, too, is just because you have a gay lesbian client, you will also have an individual there who is unique, too. And, you know, I don't know what the gay lesbian party line is. You will have an individual. But there are things you have to understand about our lives. Now, the only mistake that the lawyers made is when I got my decision, and I was quite upset. And one of the lawyers was trying to make me feel better, and he said, "Don't take it personally." And alas, there is no other way to take it. Now, what I would just like to say is that when we litigate for spousal benefits, which was and has been my shtick for 10 years, it is not about the uncritical adoption of the heterosexual model. It is not. We look at your lives, all you have to do is look in the paper this week. The family is in a lot of trouble. We know this. But it is a place to start for us. It is the rational place to start. What you have, we want to. And I know Mossop, and I know Egan, and I know Douglas, and I know Clinton, and we do not model our lives as you do on all fronts. And if we do, we make more conscious decisions than I think a lot of heterosexual people do. We are different. And it may seem that we want what you have. We want to move everybody along to a better place. And you also have to understand, as a lot of gay and lesbian people do, the staggering problems that we have because the people who mean the most to us are legal strangers. And as a corollary to that, there are significant numbers of us who have terrible problems with those in default who we have our legal relationships with, our parents, our ex-spouses, our children. And I am reminded of Somerset Maugham, and he had a terrible problem with his daughter, and he had a much younger lover, and he knew that he would have inheritance problems. So at first he tried to adopt the younger lover. It was the 50s, 60s. And you know, he was subject to great ridicule. And then he decided that he would have to give his stuff away before he died. And he died without his paintings. And it's a sad story. It's not about ridicule. I mean, nobody should die without their paintings. So when I was on the Rambles 2 years ago, which was his favorite street, and it has changed because it is a gay street, I believe that the world I live in is a different world. Thank you.
I wasn't entirely sure what I was going to talk about when I agreed to serve on this panel, and I'm not sure that I'm still entirely sure what I'm going to talk about. The subject is so vast, so immense, and there are so many issues, it's really difficult to know what particular focus or emphasis to give to it. But I think I want to talk from the point of view of being a gay man and an activist, and so obviously anything that I have to say will not reflect in any way on my role as a human rights commissioner in the province, which is quite different. One looks at things from a quite different perspective when you're wearing that hat, unfortunately. But I think that what everyone here needs to bear in mind is that these are more than just legal cases. They're more than just legal challenges. From the point of view of our communities, the legal cases, the human rights cases, are simply one tool or one vehicle or one strategy that we have available to us from an array of strategies. And we're working on a number of fronts. Part of that involves education, both within our communities and within the broader community. It means education within the legal profession and other professions and that kind of thing. Part of it is a process of building our communities, and despite the fact that this is the 25th anniversary of the founding of what we know as the gay movement in North America, most lesbian and gay communities in this country are still in their formative stages. If you look beyond downtown Toronto, if you look to other communities in this province or across Canada, the communities are still very fragile. They're grassroots organizations. They don't have money. They don't have staff. They have 3 or 4 people who, as volunteers, are spending a lot of time on these issues, and often at great risk to themselves if they're in smaller communities. And I think that needs to be borne in mind by practitioners who take up these cases. I think there needs to be an appreciation of the risks that individuals are taking. A lot of these cases are fought in the public realm. There's a lot of publicity around them, and that's not an easy thing for a lot of people in these situations to do. So a couple of things that I would suggest to you as while the lawyers, while you may know a lot about the law, I would just caution you that you may not know a lot about your clients. And I think that, as Karen has alluded to, not assuming that you know about them and their lives in the detail that perhaps you need to know in order to represent them is an important consideration, and hearing them. So if they tell you that they're not interested in the legal technicalities of the case, then I think that's an important message. For us, a lot of this is about symbolism. One of the other speakers today talked about ideology. This is an ideological fight. It really is. It's our movement in the early days used to call itself a liberation movement, gay liberation. We don't talk in those terms very much anymore, but the objectives are still the same, and in a lot of ways it's like feminism. We really are out to change the society in which we live, because if we don't change it, then we cannot live our lives in the manner that we choose and be free of discrimination and the social oppression that is the result of homophobia and heterosexism. So unless you as practitioners understand that, you're not going to understand very well the people that are coming to you and wanting these cases put forward. And one of the common complaints that I've heard about people who approach human rights commissions or they approach lawyers is that they don't really understand them and what the case is about, and they're more concerned about the legal technicalities. And while those are obviously important, they're not paramount in the minds of the people who are coming forward. And often, I think members of our communities would be prepared to lose a case on narrow legal points or technicalities for the sake of advancing the social issues, the issues around education, the issues around socialization and attitudes, how men and women relate to each other, what are adequate or appropriate role models. Those kinds of issues are often what is really involved, and other speakers have mentioned that today. Turning from that kind of broader context into what lies ahead with the defeat of Bill 167, the one thing that is apparent is that our movement and our communities are much, much stronger today than they were a month ago or 2 months ago or 3 months ago. And despite all of the rhetoric, unpleasant and hateful as some of it was, and despite the defeat of a particular bill in the legislature, this has not been a defeat for the gay and lesbian communities of the province. It's been a victory. And the reason I say that is because I was one of the people that worked for nearly 15 years to have 2 words, sexual orientation, added to the Human Rights Code, and we had defeats in the legislature a couple of times along the way, but each time there's a public debate, there's more support expressed from outside of our community in terms of other organizations, equity-seeking groups, trade unions, professional associations, community groups, women's organizations, and that sort of thing. And we saw that around Bill 167. The religious community came forward. There's a public debate. Our communities get stronger. People have come out of the closet all over Ontario in the last 2 months around this issue. It's been an amazing, amazing phenomenon, and those people are out to stay, and they're building their communities, and they're going to carry this issue forward in one way or another. Another thing that I think we're stronger on is that we've moved the yardsticks on this issue. We are now talking about those really fundamental issues. We're not talking about how much the benefits are going to cost and that kind of thing. We're talking about whether it's appropriate for gays and lesbians to be parents. We're talking about whether it's appropriate that their relationships be seen as being equal in all respects to those of heterosexuals. And so that debate will now continue on a different level and in a different way. And so the next time around, we start out at a different point than we were at going into Bill 167. We will be using the courts and the human rights commissions and other legal frameworks in which to advance the case law and to move this forward. But we will also be continuing to work on the legislators, and I think that you can expect to see, starting this fall, a very intensive lobbying campaign across the country to move the federal government and to move the parliament to change the federal laws, the Marriage Act and the Income Tax Act and the Canada Pension Plan Act and that sort of thing. So the issue isn't going to go away. It will be back. Our strategies may change. Just to close off, one important element of that we have not had up till now is a legal challenge fund, defense fund to help finance the cases. Up till now, it's been people like Karen Andrews who have paid out of their own pockets without a lot of support, whatever, hustled people in the community at potlucks and other things to raise the money that they've needed to carry these cases forward. So coming out of Bill 167, one of the things that is really gratifying is that there's a groundswell of support for establishing some kind of permanent legal defense fund so that we can start to bring cases forward. And in particular, cases around adoption and child custody, I think, are going to be in the forefront over the next little while. So I could talk about this all day. I'll stop because we really want to have questions, and there's another speaker to be heard from as well.
You've already heard probably more than enough from me. I'm just going to, well, somebody agrees. Is it there? All right. You've already heard a lot from me, so I'm going to just make two very brief comments. One is that the efforts to achieve same-sex spousal status under the law are not simply about acquiring benefits. It's about acquiring recognition, which also means shouldering of burdens. Anybody who believes for a minute that entering into a domestic partnership, whether it's akin to marriage or common law, is simply a process of collecting goodies from the state is not been married themselves. There are very serious and significant legal burdens which are shouldered by entering into such a relationship. And so the suggestion that gays and lesbians will willy-nilly run out and pair themselves up just to get benefits from the state is absolutely silly. There are also public obligations that come from that recognition. If my domestic partner is a woman, she has obligations to report with respect to insider trading. If I am a cabinet minister, she has obligations, or I have obligations to report her business dealings as part of conflict of interest guidelines, because there's a recognition of the nature of that relationship and the fact that information is likely to flow from me to her. If my domestic partner is a male, under the law, I don't have to do it, and I suppose we can get very rich without any great legal impediment. It's a burden, and it should be there. It's a correct burden, and it's one which, under the proposed legislation, would have been created for same-sex domestic partners. The second point I'd like to make is that in the course of litigating these issues and in campaigning for legislative change, there are going to be wins and there are going to be losses. And some have suggested that cases must be chosen with a special care to avoid losses. And in my view, that is not correct. There's nothing wrong with losing aside from the fact that the decision is a bad one. But it is important to stand up and wave the flag and say this is correct, this is right, this is moral, and this is just. And even if you, court, don't agree with me, I am going to stand up and say this publicly. And I will say it over and over again, and we will say it en masse over and over again until finally somebody listens.
Okay. Could we maybe start with some questions or comments from you folks? Good.
I've noticed from the new law that will be taking place in 1995, where the Consent to Treatment Act provides that you now have a categories of people that the physician needs to consider when taking a decision on behalf of someone that's incapacitated. I thought it was interesting that we're now pinpointing partners, and I hope this is a way that the government will now slowly introduce future legislation ways of improving that.
That's true, and that's definitely a step forward. The problem with it, at least in my understanding, is that you have to activate those rights. You have to do up a legal document. And while some people will do that, most people won't. And so until there is an automatic right, then I think it's only going to be a partial solution to the problem. The people who have the knowledge or who are smart enough to get the paperwork done up will have the rights, and everybody else will still be where they always were.
Anyone else have any comment on that issue? Okay, by the way, yes, and I think people should note, by the way, that that provision is in the Substitute Decision-Making Act. You know, that there are some avenues through our present legislation. Not many, though. By the way, that brings up something else, I think, which is that it is always possible for this government to put its actions where its principles are and do some things by regulation. And I wonder if our speakers could comment on that at all.
I think that would be a very dangerous thing for them to do. I think there's a similar difficulty facing the Attorney General if she simply consents to judgments in cases where these rights are asserted, and that is one of the options that's being pursued. But the legislature has made a policy decision fairly clearly And the government may feel it a very dangerous thing to do, to turn around and try to achieve indirectly that which has been defeated directly. In terms of the consistency of the policy, it would be quite consistent with the government's position to do just that. So I think it's a real political football for them, and what they'll do with it, who knows?
Anyone else on that issue? Harriet? My best information is that that is still their position, that they are not going to contest. Could you enlarge a little, David, on what might be the dangers of the Attorney General not contesting? It is, I mean, it's on the face of it, it's very attractive, right? You bring your charter case, you give notice to the Attorney General, and the Attorney General says, we're not fighting this.
Well,
I quite like it myself, but I'm sure you can point out some difficulties.
I think there are two difficulties with it. One is if the focus of the case is simply the rights of the people in front of the court, can this woman adopt this child? It will be perfectly fine for that woman adopting that child, and will result in an order that will be effective, assuming the court's prepared to do it. If what you're trying to do is establish a precedent, though, and get reasons from the court that will be useful in other cases. First, I think many judges will be very reluctant to simply make that judgment based on a consent. The court may say, well, if the Attorney General will not defend the laws of the province, I will appoint an amicus curiae who will go out, do the research, and come back and assist me to understand what the other side of the question is. The other possibility is that a judge will say, well, all right, that's the policy of this government, I'll go along with it, and we'll end up with a bunch of trial decisions that say that. They don't go to appeal because nobody appeals them, and then we get a new government elected which says, we don't agree, we're going to take a different position, and they then do take a different position in court and claim that all of the other decisions were made without the benefit of argument, per incurium, and don't stand for any compelling authority. And in my view, a judge is very likely to say, when met later on, look, you cannot change the legislation of the province by government fiat. It has to be passed in the House. This hasn't been done with argument, and with argument in front of the court, and as a result, the decision isn't binding.
Well, you have, I'm sorry, if I can just add, you have mentioned that that problem would be solved to some extent by the court appointing an amicus curiae. I would also suggest that there will be tons of interveners applying to speak to this as an amicus curiae. I mean, I don't think the court will have to appoint anybody. There will be the more vocal church organizations, for example, on a case like that, and they will be intervening. So that vigorous argument will probably be joined, but I can see that there might be some downsides to an initially attractive situation.
But they can't intervene if they don't know about it, and if it's done on consent, they're not likely to find out until it's over. I mean, if it goes to appeal, and the interveners can't intervene later to bring an appeal themselves. So I have serious doubts about whether as a long-term strategy it can work. Now, there's no downside to it. I mean, getting the consent judgments isn't going to hurt, but will it really advance the cause of securing the right ultimately? I'm not convinced that it will.
We have two would-be speakers, one here and one there. Sorry.
Yeah. But
Oh.
that also deals with a situation of legislative oversight, as far as anyone can tell, as opposed to a situation where I think an advocate in this sort of situation would find difficulty finding some arguments to bring against it. I think there's a possibility of interveners as well.
Thank you.
When the Pension Commission of Ontario takes the position that a fund, any fund that applies to recognize same-sex spouses will not be given permission to do so, then you have pension funds kind of not acting, and they also feel jeopardizing their registration status under the federal law if they do so, and it becomes very costly for them to make a change. But I wanted to ask Tom if the Human Rights Commission has approached the Pension Commission of Ontario, or is doing anything to bring pressure to bear on them to force a policy change on this issue.
No. Not that I'm aware of. I think it's the kind of role that the Commission should be playing, not only on, or should be taking, position it should be taking not only on this but some other issues. But at this moment, I'm not aware that that's under consideration.
Possible action that can be taken in the future? How would you see this case coming? How would you see the pressure coming on the Human Rights Commission to take that action?
The pressure has to come from someone onto the Commission. That's generally the way. It's a political process like anything else, and that's generally the way things get done. Someone would have to bring it to the attention of the Commission and ask that they take it up. The Commission does have the authority to initiate investigations, but rarely uses it. So it has to be, unfortunately, somebody who would draw it to the attention of the Commission and ask that it be done. Somebody would have to file a complaint against the Pension Commission of Ontario or something like that. My own personal view is yes, it would be. I can't speak for the other commissioners on the subject. There's also a question that you always get into about allocation of resources and priorities, and unfortunately the Commission is preoccupied with its caseload and whittling down the caseload that it has, so there's a natural ingrained reluctance to go out looking for other cases. So it's all part of a process that can be quite frustrating when you're involved with it. But not that I'm asking people to file complaints or anything, but certainly that would be the way that the matter would have to be addressed, would be for somebody to file a complaint against the Pension Commission.
Yes, certainly know how to make an entrance. There was a question pending from Bill Pentney, but I can perhaps come to you as soon as Mr. Hawks has made a short few minutes. Can you, do you think? Just, well, we were, what's left? We were, to be a little more formal about this, we were discussing essentially issues, what are the real issues in front of the community at the moment, and the range of responses that might be expected, and we'd love an update on what you've just been doing. And we were going to sort of make that a 5-minute-er and then open things to discussion and comments and questions, which we'd started, but we're awfully happy to have you here.
Someone can help me watch the 5 minutes. I have a habit of going over time. Just tell me it's time for the offering and I'll stop. I know my time is up. I just came from a meeting of the Justice Committee, and the meeting began with the chair saying that the agenda was to discuss the ammunitions bill, and they proceeded to discuss it with no comment about Bill 45. Partway through that, Tim Murphy very weakly raised the point about that some of the government members had hinted after yesterday's meeting they might change their vote and support the reintroduction of Bill 45, and were they prepared to do so. And the chair ruled him out of order. And so the matter was left there. And one of the government members came outside and spoke to us and said that where it leaves it is doesn't mean Bill 45 is dead. It still remains on the agenda, but at some point it will need to be brought forward by someone, and that the NDP had she said, a lot of fights in the caucus this morning. The Justice Committee members tried to persuade the caucus to change their mind and support bringing forward Bill 45. And there was a lot of fighting in the caucus, and the decision was not to do that until the Liberals would guarantee enough votes to pass it. And my comment was, why would the government ever think that Lynn MacLeod, who one day might guarantee the votes, might not change her mind the next day, since that's been her pattern? And so Bob Gallagher and Mary Wu Sims from the campaign, Mary Wu is the co-chair of the campaign, along with Tom, made comments to the press afterwards in our disappointment at the politicians continuing to flip-flop and continuing to play games with our future and to blame each other for that, and to call upon particularly the government at this point, because at this point it's the government that is refusing to proceed with Bill 45. Tim Murphy has moved it, and it was the government members who turned it down. They are so angry at the Liberals that they're not going to proceed until the Liberals guarantee the votes. And it was our position that we want it to go forward so that we can get more public education on the issue and continue the debate and the discussion. And we can deal with the disappointment. We can't deal with the continuing discrimination. What I was originally going to talk about today in my 5 minutes was to talk about some of the issues facing gay and lesbian people, and just to give you a couple of examples about that. I had a phone call from one of the women in my congregation who was panicking on the phone, and she said, "Could you come to the hospital quick? My lover's just been hit by a truck." And so I went down, and her lover had gotten out of their van to mail a letter and got hit by a truck and was rushed to the hospital by ambulance with blood pouring out of her head. And St. Michael's Hospital happened to be the nearest hospital. She went and she asked when she got there, she said, "Well, how is she? Is she okay?" And they wouldn't tell her. She stated to them, "I'm the executor of the estate, and I'm the power of attorney for her in her will, and the power of attorney, what is going on?" And they wouldn't tell her. I arrived, and I can be a little bit pushy, and did my best to be so, and it took us an hour and a half. And we could get no information about whether the lover was dead or alive. And it wasn't until I went up to see the chaplain and said to the chaplain, "This is wrong, and you're going to correct this." And she did, and we went down within 5 minutes. We were taken into the room where the lover was sitting up, and they had treated her, and she was okay. We found out that they had called long distance to Ottawa 3 times to inform the parents of what was happening, but would give no information to her lover whether her lover was dead or alive. And that is a graphic example of what is happening in this province because we have no rights. And if we happen to get a Liberal nurse or a Liberal doctor in a Liberal hospital, then we are treated fairly. But if not, then we are denied access. And there are lots and lots of gay and lesbian people around this province in less liberal locations who don't even dare ask to have access. There are examples of people who have to risk losing their job simply to get a day off work to go to the funeral of their lover. Last year, our church did 52 funerals. Our church alone, 52 funerals last year. And when Mamaleti got up in the legislature and he said this is about AIDS, he's right, it is about AIDS. Because our people are dying, and we want to be able to visit them. We want to be able to go to the funerals. We want to be able to have rights to property and to make sure that those are protected, and so we don't have to spend all of our money in courts defending those rights. And we believe that the politicians have misread the public mood, that Ontario is changing, has changed dramatically over the last 2 months, that the excellent campaign that's been co-chaired by Tom and Mary Wu have changed the attitudes of a lot of people in this province, and the opinion polls are showing us that, and that the public is moving more and more on our side. And so now we're going to have to be talking to a lot of you a lot in the next few years with court cases and working on federal legislation and on other areas to try and move things forward. The final thing I want to say before we take up the offering, final thing I want to say is donate it to the campaign. Our church has already raised close to $20,000 for the campaign, so I'm pretty proud of them so far. On the day before the vote on Bill 167, when the campaign office got the phone call that that the bill was to be amended and the definition of spouse changed, and that, you know, for me at least, was not a big deal. As long as domestic partner was there, so we could have the same rights, I don't care what they call us. But when they said that adoption was being removed, and that what I call friendly adoption, I don't know if that's a good phrase or not, but the right of a co-parent to adopt a child that's already in that relationship, when that was also, everything was going to be removed, I had to call a woman in my church. She's on the board of our church, and she's adopted two daughters. And I'm the godfather of one of them, and my lover John is the godfather of the other. And I had to call her up, and I said to her, I said, Lorraine, I'm sorry. They've just taken out the full adoption clause. And I said, we tried real hard. Because Lorraine knows that if anything happens to her, Mary's going to have a hard time keeping those kids. And even if she's able to go to court and fight to keep those kids, the insecurity and the turmoil that that's going to cause that family unit is inexcusable. And Lorraine said, well, Brent, we tried hard, but it's better to save something than to lose everything. And with the likelihood now that Bill 45 will not be coming forward, we may have gained a lot in terms of public support and education, but we haven't gained anything in terms of legislation and rights. And I just hope that that someday we'll have either the politicians or the judges who will make decisions based on what's just and not make decisions based on being scared by the religious right, and that some of the injustices that gay and lesbian people have to face every single day. Today at church, a letter came to me addressed to the Toronto Pedophile Association, Brent Hawk's director. And inside was a page from the Toronto Sun that had my picture on it. Not a very flattering picture, but had my picture on it. And the person had burned the face off the picture. And I've been the pastor of the church for 17 years, and a few things like this have happened over the years. Not many, but a few. And I've been able to handle it, say it's part of the price of being in leadership. But that kind of scared me today when that happened. And part of the fear that came from me was to remember being raised in a small town in New Brunswick and realize that some folks in rural communities all across Ontario regularly face that kind of fear for their own personal safety for being able to come out as gay or lesbian. So they have the choice: do they stay in those places and risk that danger to personal safety, or they move to Toronto? And I just think that the leadership of the gay and lesbian community in Toronto and our friends need to rededicate ourselves to keep coming back and to keep fighting to get the laws changed so that people can live their lives in dignity and without fear. And if another gay or lesbian person has to sit in the hall while their spouse is dying, then each one of us, whether we're gay or lesbian or not, have to accept responsibility for changing that situation. We've got to do something about it.
Thank you. Back again. Comments from the panelists? Questions or comments?
I have one comment, which relates to why this is such an important legal issue and not just a social one. In the modern time, the most open and permissive society with respect to rights for lesbians and gays was Germany in the 20s, where there was a vibrant rights movement, which was viciously suppressed by the Nazis in the 30s, leading to concentration camps and extermination of gay people, just as that treatment was applied to Jewish people and gypsies. And that's where the symbol of the pink triangle comes from. That was the brand that the Nazis used for gays. If it's not recognized in our supreme law, it can happen anywhere. It happened Germany was a civilized place. That's why the fundamental protection is so important.
As a follow-up to that, I would like to say that I think the most important things said were by Harriet Sachs, who said that There's more going on here than making the right legal argument. And lawyers cannot forget that. And litigants cannot forget that. And politicians cannot forget that. It is not about dazzling legal argument. It is about hatred and bigotry and fear. And I think it's a humbling experience for those of us who have law degrees.
I'll just pick up on that, and I agree with all of that, and I also said earlier that sort of the legal battles were just one of an array of strategies, but at the same time, I don't think we should underestimate, obviously, the importance of those battles. And one of the things that we've seen as a result of the amendment of the Human Rights Code in 1986 is that a change to the law has in fact led over a period of time to a change in attitudes. For example, we're talking about recognizing relationships now instead about the right to keep a job or to rent an apartment. So it is important that these cases go forward. They do move the yardsticks, even if they take a long time. And I think that while they become debates around rights and equality and that sort of thing, I think they are also in some ways these campaigns are sort of referenda on Ontario or Canadian society and the values that we have. And I think the specific focus on changing the laws is useful in that regard, and it is incremental. And so if we have another version of Bill 167, it won't eliminate, and it's passed, it won't eliminate all of the discrimination that gays and lesbians face, obviously, but it will allow us then to move on to one of the other areas. Yes, there are other areas, unfortunately, but it will allow us to at least get beyond that point and move on to some of the other areas where there are still discrimination. So I wouldn't want to leave any of you here with the notion that the community doesn't view these legal challenges as being important. We do, but they are seen in a broader context, and I think it's important for you to go away understanding that as well.
If I could just follow up, I think that the comment was made, and may have been made here today before I arrived, that human rights are more often won in courts than in legislatures. And I think that's true. And in the midst of making the dazzling case, I would also ask, please give voice to our stories. Please give opportunities in the midst of that for the judges, etc., to hear the stories of gay, lesbian people. Give examples, specific examples, because it's those stories that impact people to look beyond the legalistic, narrow interpretation of the law. And so there's the organization Coalition for Equal Families, there's Coalition for Lesbian Gay Rights in Ontario. There's lots of places to go where those stories are readily available that can give a human face to a legal discussion. And it's been my experience out in dealing with the public and sometimes dealing with really ranting and raving right-wing fanatics that it's the human side of things that impacts them to really listen and consider changing their opinions.
I don't think that can be said too often to an audience of lawyers, and Harriet did bring it up, and other speakers have brought it up, and particularly in the area of human rights. By the way, I think this is one of the privileges of working in the area of anti-discrimination and human rights, is that it's incredibly constructive on a personal basis. You don't feel you're wasting time. You feel you're contributing your little bit to a community you want to live in. I get sort of choked up on these issues, and I want to just go to a couple of people who had their hands up, by the way. Susan, Ursel, and Bill Pentney both had questions, and looks like there's lots of questions, so let's continue. thank you for that constructive approach. Bill Pentney, and there are two other questioners or commenters. I'm sorry, I don't know your names. Bill.
I just wanted to make a comment, I suppose, as a start to what Susan was talking about, and it's in terms of I understand the focus on Bill 167 in Ontario and the history of it, but people should realize that in Alberta, basic human rights for gay and lesbian people are not protected. Breen said at the Court of Queen's Bench level that they ought to be protected and ought to be read into the Individual Rights Protection Act. The government of Alberta has appealed that decision, and about a week and a half ago obtained a stay pending the hearing of the appeal, so that the Alberta Human Rights Commission can accept and receive complaints, but cannot investigate or deal or process or otherwise try to resolve those complaints. The second case that people should be aware of is that the Newfoundland Human Rights Commission has referred a constitutional question to its superior court, asking that a number of grounds be read into the Newfoundland Human Rights Code. One of those grounds is sexual orientation, and that reference is underway. And finally, people should realize that despite Hague and Burge, the Canadian Human Rights Act still does not expressly recognize sexual orientation as a prohibited ground. And the constitutional effect of an order of the Ontario Court of Appeal in respect of federal statute is a nice little constitutional law exam question for somebody at Osgoode Hall, but also has very practical effects for people who don't work in the public service, because the federal government has accepted that Hague and Burge will apply across the country. But Bell Canada and other employers haven't declared publicly that they're prepared to accept that. And so I think that both the symbolic and practical importance of maintaining a focus on the Canadian Human Rights Act is something that's worthwhile. The final point I'd make is that the Quebec Human Rights Commission held some public hearings into the issue and have issued a report, and I think both the hearing process and the report itself are things that people in Ontario and elsewhere should pay some attention to, because overall I think it proved to be a fine piece of work, both the process itself of allowing people to speak, the news coverage over a sustained period of time that obtained, and now the report in terms of a resource for people to look to. That's not a question, I just thought people should take
Yeah.
a position.
Well, comments are certainly invited too. You, sir.
Yes, I just wonder if any of the panelists have any thoughts about how we translate lesbian and gay activism into litigation strategy. It's become very apparent as we have discussions within our own communities about different models of relationship recognition and some of the different alternatives open to us. The thinking within our own communities is light years ahead of the courts and the legislatures. When we step into the courtroom, it's like stepping back 20 years, and as Karen says, having to start off before we even get to the discussion of the legal items with them, we're not ones who we're not facing, or we are facing those basic bridges, trying to overcome the limit into our arguments. Do we just accept that we have to work within the legal paradigm to a certain extent, or how do you think we can push the strategies we develop within our own communities at an activist level and dealing with courts?
Maybe I'll take the first crack at that. I'm not sure what the answer to that is, because, well, I'll give you an example. When the Coalition for Lesbian and Gay Rights in Ontario started in 1989 to sort of formally articulate what it was that we were seeking by way of legislative changes around relationship recognition, there was this whole debate about whether we even should be doing that, because our relationships in some ways are quite different, for a lot of, at least for a lot of us, are quite different than for heterosexuals. And that raised the whole question about whether or not we simply wanted to have reflected in the laws a structure, a family structure legally that we had some problems with, and transfer that onto our own community and our own relationships. And it's interesting because we thought that we would have to do that as the first step. That's what is there now, so let's amend what is there now so that we are at least on this, have the same legal standing as heterosexual relationships, but not necessarily view that as an end in and of itself, and work in a broader context towards maybe even changing the legal framework, not only for us, but for heterosexuals who want to live in sort of non-traditional relationships but not be disadvantaged as a result of that. Interestingly enough, I think toward the end of the debate around Bill 167, we've ended up in the broader position as opposed to the narrower one. And I think we got there because of homophobia, not because the gay and lesbian community was putting forward an alternative kind of model. And I think it was the whole thing around domestic partner, for example, as a different but equal status within the law in terms of relationship recognition, is an example of that. And we would like to have advanced that by way of suggesting legislative changes. In fact, we did in a limited way, but we felt that the political will wasn't there, that the legal system and the politicians weren't prepared to go that far. And in fact, we found out that they might be prepared to go that far because, at least in my own view, it preserves the heterosexual privilege around marriage and the definition of spouse and that sort of thing. So I'm not sure. I think we can look at those things, but I wouldn't have anticipated going into this particular campaign in 1989 when we started out that we would be able to get the kind of consensus that there seems to be around some alternative form of domestic partner. But I think at this point in time, most of the people in our community are prepared to accept that because it addresses their concerns as well as the same time it may address some of the fears of some heterosexuals.
This is something that the group that Susan mentioned earlier, we've been meeting for about 8 or 9 months now, and we've discussed at great length. And just our preliminary thoughts, and I'm trying to convey a consensus view, is that it is perfectly realistic to go to the courts and say, this is a set of rules which has been developed, which governs domestic relationships in our society today. We're not telling you that we say these are the best rules. We're not telling you that everybody in our community wishes to subscribe to them. But at a minimum, we are entitled to access to them if we wish. If lesbians and gays wish to get married, they should be able to do so. We're not saying that everyone does. The second question, which is really raised by Federal Justice Minister Alan Rock's proposal as one way of going about it, of just reconfiguring concepts of domestic dependency, will require for implementation a complex process of amendment of all the laws that touch our domestic relations, including all of our tax laws. I mean, it's a huge process for reconfiguring the concept of domestic legal relations. And if it happens, fine. If it doesn't happen, if society as a whole says, no, we won't do that, we should be able to say to our courts, whatever the options are that are available generally in society for domestic arrangements for heterosexuals should be available for lesbians and gays. And they are divisible questions on which the lesbian and gay community can have very strong views on both. But you can break the questions into two without purporting to answer both at the same time. Is that fair, Susan? Sure. First you've heard of it.
We have one more speaker who's already put up her hand, and then I guess I'll ask for a consensus, but it may be more realistic to think we're going to break at 5:15. Please.
Ensuring a safe environment for gay and lesbian workers is the first priority. I mean, we still hear all the time about the harassment of gay and lesbian workers around the province in various kinds of workplaces. They don't feel safe. They don't trust their unions to not be homophobic, to really encourage them to come forward if they have a problem of harassment or discrimination. So I think that's really where it starts.
Well, thank you very much. And I think some of us can stay so we could continue this conversation for a little while yet. Thank you.